Welcome to the IR Global podcast. IR Global is the largest international professional services network. I'm your host of the IR Digital podcast, Jennifer Riggins. Today, we're sitting down with attorney Lauri Railas, calling in from Helsinki, where he is an adjunct law professor, attorney, and statutory average adjuster. I guess we'll figure out what that is when we talk to Lauri. We are talking about all things contracts, especially involving trade deals, and what else about how contracts relate to this pandemic and how contracts can allow us to be more stable, especially when things feel, well, kind of less stable. So welcome, Lauri. Why don't you start by introducing yourself and talking about your firm and who you work with?
Hello, Jennifer. Yes, well, there is not much to say about my firm. I work mostly alone. Sometimes I have some young lawyers helping me, but not at the moment. I am a trade lawyer who has a very versatile background. I have been working in marine insurance. I have been working in the chambers of commerce, and I have also been working in the European Union, but for almost 20 years now I have been an attorney and dealing with international trade law issues, various types of contracts. Then I also teach at the university. I made a doctorate, and I write a lot about these things. I used to work for the International Chamber of Commerce for years, and I'm still involved with one of its commissions, namely Commercial Law and Practice Commission. And under that commission, the International Chamber of Commerce has produced a big number of instruments for helping companies to do their international trade law deals, including the Incoterms, which is a set of trade terms which companies use throughout the world. Then you have all kinds of model contracts and contracts for international sale of goods and so on. And during the last couple of years, the ICC has prepared new models for so-called force majeure and hardship clauses. I will introduce them later what they are, but I was also involved in that work. And as you asked, what is an average adjuster and a statutory average adjuster? It doesn't mean, well, I am a mediocre person, and you might call it that I'm an average adjuster, but the average means marine casualty, and an average adjuster calculates marine casualties and settles disputes relating to marine insurance contracts. Suppose that you don't get compensation from your insurance company relating to a marine insurance contract. It could be a yacht insurance. Let's say your yacht sinks into the sea, and you don't get any insurance compensation from the insurance company. So in my country, Finland, a statutory average adjuster settles disputes, so that you have to file an application to get an adjustment, and then when I give an adjustment, whether you get an insurance compensation or not, then you can appeal to the court if you don't get it. So it is part of the court system, essentially. So that is what I'm doing.
And since I know you have a doctorate now, I want to ask curiously, what was your dissertation on?
My dissertation was about the digitization of international trade law. Usually, when you sell goods, you deliver them physically. That's okay, and that is still the case. You cannot deliver anything else than software through the internet. But you can conclude contracts electronically, and what is I don't say more interesting, but at least it is essential that the trade documentation has become electronic. And so how to convey the functions of paper into an electronic form. That is extremely boring actually, but you have to have a kind of a legal system how to do it and how things work in an electronic environment. So 500 pages of that kind of stuff. It is published electronically also, and it is in English. So if you want to read it, I can recommend.
Actually, my first job in tech was at an electronic signature company, so I do realize like how much digitizing that work is important and increases efficiency and actually security of the signature and everything. So it totally makes sense to me that the whole system needs to be digitized. But I guess the problem is a lot of countries maybe aren't ready for that yet.
Yeah, that's right. And there are a lot of prejudices, but I think that the practice has evolved little by little, better off in terms of legislation. But there are many trade practices which cannot be very easily transformed into digital form. Let's assume that you have bills of lading, which are documents which are transferred from one person to another, and you use them in documentary credits. So there are too many things to be settled in such an environment to make it really working. So paper world still holds out, and I'm coming from a country which produces paper, so I'm not very unhappy about that, but it still prevails in some forms of trade, I should say.
Absolutely, but it's certainly worth 500 pages or more to talk about the transformation and how to make that transformation. So it's very interesting, actually.
Yeah, and I think that these questions are quite eternal. So basically, I wrote it 16 years ago, but I think that the basic questions are still there. And you have some progress. So I think that you don't have waybills, paper waybills very often anymore. But and that's a part of digitization. But it could be that doesn't solve yet everything. So there are still functions in which the paper is better.
Very interesting. Maybe you'll write a sequel or an update. So you mentioned terms, and we definitely want to make sure we're all on the same page about the basic principles of laws and standard contract terms that we should be prepared for in this discussion. And then as you're going, do these, obviously they vary by language, but do these terms and conditions vary by country?
Yes, they do. Basically, and I think that we are, if we are discussing international sale of goods, so that is the basic form of trade which we have had over centuries. Nowadays, services such as my services, legal services, are also important, especially for the UK legal industry. You sell a lot of legal services there. But if we restrict ourselves to the sale of goods, we have an international convention called the CISG. Its name is very long in English, but it is a Vienna Convention from 1980, and some 90 countries are parties to that convention nowadays. We have some exceptions. UK, obviously, you don't belong to the European Union anymore. Ireland, Portugal, but then many important countries such as United States, China, and Russia, and the rest of the European Union, for instance, Japan, Australia, they are parties to this international sales convention, and it provides a kind of a background law, but it is not mandatory. So you can deviate from that by your contract. So if you write the contract, it is binding, and if it deviates from the CISG convention or your national law, in English law it is the Sale of Goods Act, then the contract prevails over this international sales convention or any national law, whatever you might have. Okay, these contracts may differ from country to country. Under English law, for instance, you are not allowed to use so-called penalty clauses, which means that if I delay goods to you too late, I cannot contract that I charge you 3% per each week of the contract price for each delayed week of delayed delivery. So that would be a penalty. Your real loss is not that much, and English law prohibits that. So these clauses may depend country by country, but luckily there is a lot of uniformity, and for that reason, or in order to promote that, I have participated in the work of the International Chamber of Commerce, which has harmonized contract law considerably through its standard terms, such as the Incoterms, which regulate the costs, task and risk involved in the delivery of the goods, and also various contract clauses such as so-called force majeure clauses and hardship clauses, which are relevant for any sales contract. If you like, I can go deeper into them later.
Absolutely, because I think hardship might be very relevant in this time right now.
Yeah.
What are typical problems that arise with goods contracts?
Well, the typical problems are usually that you don't get value for money. So that is always the basic problem. You want to buy good widget, but the seller delivers you a bad widget. That is a typical problem. But then the parties also have problems who has to do what in a sale of goods transaction. Who has to do contract for carriage, on what terms does the seller or the party contract for carriage, who has to insure the goods, who has to clear them through customs, and so forth. And these matters are regulated by the Incoterms. Well, if we go to these problems further, and especially in the era of the pandemic, we have to start from the fact that the parties have to do these various things. They have to deliver the goods or take delivery of the goods. So they have to receive the goods, and they may not be prepared to do that. For instance, in my country, produces a lot of machines, and these machines contain a lot of components which come from, let's say, from China. And during the pandemic, we were not able to get those components. So the seller cannot deliver, and it is supposed to deliver a machine on day one, and it cannot do it because some of the relevant components are missing. So is there a delay in delivery for which you have to pay liquidated damages? Perhaps, but perhaps not. If you say that there is an impediment beyond your control, which you have not been able to foresee, when the contract was concluded, and which you cannot avoid or which you cannot correct by other means. Then you can say that you are in a force majeure situation, which means that it is impossible for you to deliver. That is force majeure. And the effect of force majeure is that you don't have to pay any damages in order to remedy the situation. You simply say that I didn't get those components because there is pandemic, and therefore I cannot deliver, and I don't have to pay anything to you. And the model international force majeure clause makes it easier for all parties to apply the same terms to force majeure. Then there is another possibility. Okay, I can say that, okay, I didn't get the components from China, but I know somebody in let's say, Austria who could produce them, but they are so much more expensive that I don't get any profit if I buy them. And in some countries, this is called hardship, and hardship occurs when prices of the goods are components are so high all the time that you cannot make any profitable business. Then you can say that you are in a hardship, and you need a hardship clause to tackle the situation. And it is possible that in many countries and under a hardship clause that you go to the court or arbitrator should you have agreed that your disputes are to be settled by arbitration, and the court or arbitrator then adjusts your contract. He says that okay, you can charge 15% more from your customer because your components are so much more expensive, and that is called hardship. Under English law, you don't have this vehicles or legal tools. You talk about frustration, which is a physical thing, or not physical but psychological thing, but it's also a contractual thing. So contract simply dies out because it's so difficult or impossible that it is frustrated. And but in England you cannot go to court to ask that they adjust your contract, make it more feasible for us. But if you have a hardship clause, you can do it. And this is what international law has, international commercial law has developed over the past 50 years or so. I think the hardship started really when the oil crisis took place in the 1970s. Oil prices became fourfold, or I don't remember exactly how much they rose, but in any case, in the 1970s, you started to introduce so-called hardship clauses in your contract.
So talking first about the force majeure, which hopefully I'm pronouncing okay, how long does that go until? Because obviously the pandemic hit the world, and especially because China is the factory of the world, very hard. But we're now 6 months into it. It doesn't seem unforeseeable that we may have another year until a vaccine, until we can, and that's even if we can get the vaccine everywhere. So this is something now that's kind of, I hate this term, everyone hates this term, but there's no other way to say it, the new normal. So does force majeure still take effect, or are you seeing a change in contract law where they say, well, this is the price we've guaranteed now, but in case something happens that this supplier goes in lockdown again, then we have this supplier, but then it will cost this much? Are people validating that idea? Because are they like basically contracting contingency plans, contracting corona contingency plans?
Yeah, well, your question is very pertinent. actually buyers do not no longer accept invoking force majeure, and the reason is obvious. If we talk about the pandemic, it has been around for 8 months now. In March, it was really obvious, and I think that the turn of the year, this year, January 2020, was the time when the pandemic became foreseeable for companies. And if your contracts was concluded last year, then you can surely invoke force majeure still, but many supply contracts of goods, they are, let's say, framework agreements. You agree on the price level, but the actual orders take place later. Let's say we have a 2-year delivery program, and each time you need new products, new raw materials or components, you order them. And I think that each of these orders are separate contracts, and let's say you order this month for the production of next month, so your contract is concluded now, and not the framework contract which was concluded, let's say, two years ago. And obviously that creates a new environment for contracting, and you have to take into account the new circumstances which prevail now in your production and so forth. For instance, the prices may have gone up considerably, and or may go up considerably due to the impediments in production, and you have to take that into account when you write your contract. You have to tailor your contract clauses to take into account all the contingencies that may happen in your production.
What else is considered in these unforeseen events categories? I guess natural disasters would be a logical one, but what about something like global heating? And obviously Finland's doing better than probably the rest of the world with fighting climate crisis, but things because of that, like, I don't know, is that considered foreseeable?
No, global warming is certainly foreseeable, but it progresses slowly. Well, not slowly when terms think about our life in general, but when it comes to contracts, climate crisis could create hurricanes, which could be natural disasters. They might become more normal. But nevertheless, they are still unpredictable. We cannot predict when a hurricane occurs, for instance.
Or fires in California.
Fires in California. Yes. Well, yes. They are. We know that they exist, but they are still unforeseen when it comes to contract law, because we never know when exactly do they occur. Well, obviously they occur in the summer and autumn when it is hot and dry, but we cannot tell it exactly. But this will be a big challenge for contract law and for insurance, of course, because the insurers must cover you against the risk of the unpredictable. So that is also the relevant basic principle of insurance activity and law, that you insure against contingencies and not inevitabilities.
Well, certainly Wimbledon is winning the contract race of having had that insurance going on for I don't know how many years, and got a massive payout for cancellation due to pandemic. And I guess everyone else thought they were crazy because pretty much no other sporting event had such a clause, but look at them. Is your job changing day to day? Are the conversations you're having with clients changing day to day because of specifically, I guess, the coronavirus, but perhaps it leads to other thoughts of your client?
The clients are trying to adjust themselves to the current situation. I would say that I am being contacted to surprisingly little about these things. I think that I'm more involved in all kinds of training activities, which seem to interest people a lot. I don't get that number of phone calls relating to the pandemic that I could have expected. And I think that my colleagues are also telling the same story, that not as much as we would have thought. But there may be disputes arising about this after the whole mess is over, because then the companies have, when they are in real trouble, they have to settle their problems, and when they have a little more time, they start arguing and litigating and fighting these problems that they have had in their past. But we shall see.
We shall see. So it's very interesting because if you think about it, something we haven't even touched on yet is labor contracts, but how many people can be on a ship together? Things like that, or international laws, or country laws about borders, and that's a fluctuating thing with corona, or maybe they're allowing trade to continue even when a country's banned, things like that. But it's certainly in a very interesting area you are working in that we don't think about because it goes on in the background.
Yes, in one of my recent articles, which are also available to the members of the IR Global, I have actually published them on the internet. I was saying that we can certainly foresee or predict the occurrence of the unpredictable. So that as you said, it is becoming a new normal, and we have to think about all these contract law tools when we go forward. The starting point in contract law is that the contracts are binding, and many lawyers oppose the idea that the courts would adjust your contracts because it creates an element of unpredictability. But at the same time, if you adjust your own contracts by writing clauses which say that you can take into account all kinds of developments which may affect the price. Actually, contracts govern the pricing mechanism. How can you earn money by delivering goods? It is actually your contract which makes the life in a way more unpredictable, because uncertainty becomes part of your contract through various contract clauses, and the contracts themselves become kind of vehicles of uncertainty. I don't know if I make this clear, but if you build in all kinds of adjustment clauses to your contract, you don't actually know what you have agreed to.
So are you saying that contracts should be kept very straightforward and simple?
No, I'm not saying that, but we need to have these types of clauses, but the basic idea of contract law has been that the contracts are binding, as they say it in Latin, pacta sunt servanda, and that creates predictability, and that has been the idea for centuries now. Lawyers also need and companies need to think about the possibility that they can maintain their relationship with somebody, and even though circumstances change a lot. So if you have a good friend, it doesn't really matter if you have a lot of money or less money. Usually that should be the case, and that may be the case also with contracts. Even if you and your clients both are doing badly, it is still worthwhile for you both to have your relationship going on, and not break it because you don't earn as much as you should do, or you think you should do.
These are exceptional circumstances, and we should try to be exceptional human beings.
Yes, we should exceptional human beings, and some sort of reasonability, equitability should govern our relations also, because I think that it will pay back one day. I should say fairness. I think many legal systems they have very complicated wordings, but they try to achieve some sort of fairness, and also court try to achieve that. What is not fair cannot be law.
What is not fair cannot be law. That's beautiful. But on the other side, if both sides have a verbal agreement to say, okay, this time this contract does not bear because we understand your products may be late or you may charge more, does that need to be written down? Does that need to be part of a contract? Well, I love the idea of being reasonable and good human beings. Does that then in itself need to be a contract addendum or something?
Yes. Well, if you have a written contract, it is binding, and if you undertake to deliver on day one and you don't, there will be consequences. And fairness does not count in that. Whereas if you are a company and you sell something, you are bound by your undertaking. You cannot say that I did my best. That is not enough. So you are strictly liable for what you undertake to deliver. And if you don't, you are bound by those contract clauses or laws which apply. You cannot simply say that I tried my best. So normally companies need a hardship clause in order to tackle unforeseen circumstances, or a force majeure clause which relieves you from liability if you fail to deliver on an individual contract. These kind of contractual law tools are necessary. Many lawyers think that you shouldn't have any hardship clauses because that creates uncertainty, because a court or arbitral tribunal may adjust your contract. But then as I tried to say, if you tackle the same problems yourself by your contract, you create adjustment clauses, price adjustment clauses, or all kinds of adjustment clauses to your contract, then you actually create the same uncertainty yourself. So it is the circumstances which may, unforeseen circumstances which may occur, and these are addressed in your own contract already, and not by arbitrators or judges. They may not understand your contract much less than you do it yourself. In that respect, you are in safer hands if you do it yourself through your contracts.
Well, thank you so much, Lauri, for leveling us up on all things contracts and reminding us that we're not robots, that contracts are among humans and not just businesses, and that we have to be cognizant right now, especially, that these are exceptional times, and maybe we can make sure our contracts are prepared for those exceptional times. If our listeners want to touch base with you to learn more about you, contract law, if they have any questions, what's the best way to get in contact with you, Lauri?
Yeah, well, you can always reach me through my email, Lauri at railas.fi. And if you want to read more about the things which I have just talked about, you can reach out to articles of mine which I have published a few months ago. One of them is about force majeure and the other one is about hardship, and you can have access to them through IR Global.
Great. Thank you so much, Lauri. And thank you, listeners. These IR Digital podcasts are meant to be educational resources from experienced lawyers, accountants, and financial advisors with clearly extensive knowledge on topics you as professionals need to know about. To learn more about IR Digital and its services, visit irglobal.com. And if you found this episode useful, please consider sharing it. Thank you so much and have a great day.
Thank you.